Poor Donald Trump. He's been fined almost $1 million for a lawsuit he brought against Hillary Clinton. Is this just more political attacks on the former president? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So the headline, of course, is that Donald Trump's been fined almost $1 million as a result of a lawsuit he brought against Hillary Clinton. This lawsuit, unbelievably, is for damages he allegedly sustained in the 2016 election that he won, and that for all their talk about how Democrats didn't accept the result, Hillary Clinton acknowledged that he had won in a press conference the day after the election, and President Obama, who of course was no Donald Trump supporter, told Democrats not to worry, the sun will come up. So how is it that in 2022 he's filing a lawsuit against Hillary Clinton for the 2016 election? Well, that actually is a good question, and it's a question, frankly, that puzzled the judge in this case. Federal Judge Donald Middlebrooks for the Southern District of Florida. Let's go through this opinion a little bit, which actually is very well written and very thorough. Some might even say powerful. I mean, check out this opening statement here. This case should never have been brought. Its inadequacy as a legal claim was evident from the start. No reasonable lawyer would have filed it. Intended for a political purpose, none of the counts of the amended complaint stated a cognizable legal claim. Now that's important language here because the federal rules under Rule 11 state that a complaint has to be based upon some type of recognizable legal claim. You can't simply make stuff up and use the courts for your own purposes. But the judge in this case goes even farther, saying that Rule 11 doesn't go far enough, that the depths of this abusive process warrant serious sanctions against both Donald Trump and his attorney. Let's see what the opinion says. Down here, when the judge talks about the background of this case, he points out that Hillary Clinton filed a motion for dismissal shortly after the case had been filed. A motion for dismissal says that there's nothing really to litigate here. Under the law, there is really no basis for this case. And as the judge points out, each of the other defendants followed suit, pointing to specific problems with the claims against them. The problems in the complaint were obvious from the start. They were identified by the defendants not once but twice, and Mr. Trump persisted anyway. In other words, what happened is that first the plaintiffs, being Donald Trump of course, filed a complaint. The defendants responded saying, this complaint has no basis under the facts or the law. Donald Trump's attorney then responded to that with what's called an amended complaint, basically changing the complaint to try to address these deficiencies that were identified in the pleadings by Hillary Clinton and the other defendants. The judge, though, was not that impressed with this amended complaint, saying, plaintiff added 80 new pages of largely irrelevant allegations that did nothing to salvage the legal sufficiency of his claims. This is strong language for a judge. In fact, I go through a case with my students where I talk about how the judge's writing that something is conclusory is basically saying someone's an idiot. Well, this opinion goes far beyond that. I mean, check out this comment. I found that the amended complaint was a quintessential shotgun pleading. Shotgun pleading meaning that you just throw a bunch of stuff at the wall to see what sticks, but that you really have no basis for it. You're just hoping that something sticks. That its claims were foreclosed by existing precedent, and its factual allegations were undermined and contradicted by the public reports and filings upon which it purported to rely. In other words, that they make claims based on certain documents, but the documents themselves contradict the claims that Donald Trump is trying to make in his pleadings. We'll revisit that a little bit later on. Now, this is a serious issue, as the judge points out here. Tampering with the administration of justice involves far more than an injury to a single litigant. It is wrong against the institution set up to protect and safeguard the public. Courts are supposed to be a place where justice is done. I know that a lot of times justice doesn't get done. I mean, I'll be the first to admit that. But in theory, at least, we need a system where the courts are respected to one degree or another. And anytime somebody uses the courts for this type of political hatchet job, they undermine the purpose of the courts in the first place. Now, what does it take for a judge to find that there should be sanctions brought against litigants? Well, the judge says right here, the key to unlocking a court's inherent power is a finding of bad faith. So they basically have to say that this case was filed not in good faith, where they were trying to either make a certain novel argument or maybe advance the law in one way, shape, or form, but that from the get-go, it was filed in bad faith, that there was no basis for it. So the judge actually goes through a whole discussion to review this. And the judge finds, here we are confronted with a lawsuit that should never have been filed, which was completely frivolous both factually and legally, and which was brought in bad faith for an improper purpose. Again, trying to score political points is not a basis to bring a lawsuit. Mr. Trump is a prolific and sophisticated litigant who is repeatedly using the courts to seek revenge on political adversaries. He is the mastermind of strategic abuse of the judicial process, and he cannot be seen as a litigant blindly following the advice of a lawyer. He knew full well the impact of his actions. The reason that's important is that the judge is trying to make the point here that Donald Trump knew what he was doing. He wasn't approached by some attorney who convinced him of some pie-in-the-sky theory that he went along with. No, this is actually part and parcel for the way that Donald Trump proceeds. So now the judge goes into more detail here. The deliberate use of a shotgun pleading is an abusive litigation tactic which amounts to obstruction of justice. I mean, those are strong words here. So what is the basis the judge uses to back that up? Well, as it turns out, he has a basis to do so. He says, the 819 paragraphs of the 186-page amended complaint are filled with immaterial, conclusory facts. Again, conclusory is one of those words that I use to describe to my students as basically a judge calling someone an idiot. Not connected to any particular cause of action. Consider the incendiary charge that Mr. Comey, the director of the FBI, conspired with Miss Clinton to maliciously prosecute him. Now, wait a minute. Number one, Donald Trump wasn't prosecuted. Number two, as I recall, wasn't James Comey the one who made that announcement about additional emails being found on a computer that needed to be reviewed? That there's a lot of evidence showing that might have been what tipped the election to Donald Trump. And certainly in such a close election, I would say the announcement by James Comey right in the midst of early voting had a serious impact on Hillary Clinton's campaign. So now he's saying that James Comey was actually helping Hillary Clinton? I think Hillary Clinton would probably say, please don't give me any of that kind of help. Let's keep checking this out. According to the judge, the amended complaint is a hodgepodge of disconnected, often immaterial events, followed by an implausible conclusion. This is a deliberate attempt to harass, to tell a story without regard to facts. So then what the judge does is he looks at other cases where courts have found that there was abuse of process and compares them to this one, finding that in each case, this one is even worse than those other cases where the courts had found that there was an abuse of process. So what's the basis for that? Well, apparently, as the judge says, the plaintiff consistently misrepresented and cherry-picked portions of public reports and filings to support a false factual narrative. Then the judge gives examples of that. For example, the Mueller report is quoted as being something that, quote, found no evidence that Donald Trump or his campaign ever colluded with the Russian government. And yet, as the judge points out, the Mueller report does not exonerate him. That's a quote from the Mueller report, by the way. Then the Crossfire Hurricane investigation. Supposedly, the Inspector General's report supported the narrative that Donald Trump was improperly targeted, but as the judge points out, the IG report found that the FBI opened the investigation, quote, for an authorized purpose, and, quote, with adequate factual predication that had nothing to do with the defendants or the Steele dossier. Another example that I love is the judge points to repeatedly pointing to criminal indictments such as Sussman, Danchenko, and Klansmith. And as the judge points out, the indictments themselves are not relevant. In fact, he says, an untried indictment is not evidence of the conduct alleged, which he's right about. But what he neglects to mention, by the way, is that these indictments, in the case of Sussman and Danchenko, well, they were both acquitted by unanimous vote of the juries, who decided very quickly that there was no basis for the government prosecution. Then the Twitter suspension. I love this one. Apparently, Trump claims that he was suspended from Twitter because of, quote, the misinformation campaign waged by Hillary Clinton. And yet, The judge points out that Twitter suspended Mr. Trump on January 8th, 2021, 2 days after the January 6th attack on the Capitol, because it determined Mr. Trump's tweets posed, quote, the risk of further incitement of violence. In other words, it had nothing to do with Hillary Clinton. Then the judge points out that the plaintiff's legal theories were frivolous, foreclosed by existing precedent. And I love some of the examples that he points to here. For example, he points out that Donald Trump claims that he was maliciously prosecuted, but yet there was no prosecution. You can't have malicious prosecution without prosecution, right? He claimed that there was a trade secret claim, but yet there was neither trade secret nor ownership of trade secret. And then he claims that there was obstruction of justice, but yet there was no official proceeding that was being obstructed. Then the judge goes into one of the most interesting parts of this opinion, where he talks about a pattern of abuse of the courts, where he acknowledges the fact that generally courts won't look at past abuse, past behavior by the plaintiff, but in this case, as the judge writes, it's part of Mr. Trump's pattern of misusing the courts to serve political purposes. Then he goes through a litany of different cases: Trump v. Pulitzer Board, Trump v. New York Attorney General, which, by the way, this case was dropped shortly after this ruling came out, Trump v. Twitter, Trump v. CNN. And in each case, the judge points out just how baseless those cases were. So the judge's point is that this is not some mistake, some good faith mistake made by the plaintiff. The plaintiff knew what he was doing and did it on purpose. He was not led down a primrose path by an attorney. He knew what he was doing and urged the attorney to move forward with litigation without any basis. Next, the judge goes through the damages. And of course, again, the headline is $1 million. Everybody thinks, oh, you know, the judge just picked $1 million out of the air, that this is all part of a political attack. And yet, that's not the case at all. Right here, the judge writes, defendants request $1,058,283.50 in fees and costs. Then the judge goes through those fees and costs at length, specifically pointing to one set of fees and costs for the defendant Joffe that he reduced. However, the judge finds that the rest of the rates charged by defendant's attorneys are reasonable. And again, after going through an exhaustive review, he finds that $937,989.39 is the appropriate amount that should be paid by the defendants to the plaintiffs. Now, just who has to pay that? Well, as it turns out, the judge holds that the plaintiff's lead attorney, Alina Habba, and Habba, Madayo and Associates, and plaintiff Donald J. Trump are jointly and severally liable for this money. What that means is both parties are fully responsible for the full amount until it's paid in full. Is it possible the defendants could get all that money from Donald Trump? It's certainly possible. Is it possible they could also get all that money from the attorney? Also possible. Either way, this is a damning indictment of Donald Trump's behavior in the courts, a complete undermining of the credibility of his attorneys. And frankly, on top of this attorney should face sanctions, I would think, from the bar. And for once, it finally holds Donald Trump accountable for some of his behavior. But this is not the only judge who said strong things about Donald Trump. As it turns out, the Supreme Court did as well. Check out this video over here where I talk about that. I'll see you then. In the meantime, let's hope for continued progress. Thank you.